The reason why intellectual property rights are a sensitive issue is because, one, there's plenty of different ones. Some people only think about copyright when they hear IPR, but of course there are other issues such as the geographical indications that are important for a number of people here in the Parliament, and that many consider to be a major offensive interest of the EU vis-à-vis the United States in this issue. It's sensitive because of the question of how the enforcement of intellectual property rights in today's day and age that's highly digitized impacts individual liberties, people's digital freedoms, how they impact access to medicine, access to knowledge. And so a lot of questions are out there.
I'll give you a few, not definitive ideas and hints, but I will give you a few pointers on what we think could be done. I mean, one area obviously where we will have to look at very hard is the whole question of the trademark and the patent system, especially upstream, before actually the decision is taken. I mean, the actual granting of the patent or the trademark, as I said, is deeply entrenched in the national or in the EU and US context, but there might be quite a lot of things we can do in how to get there. I mean, there are databases which are not necessarily open to the other side. There are processes which are duplicative, even if there are maybe somewhat different standards to work with. We have to look at that.
In the age of globalization, it's very, very difficult to talk about necessity in terms of protectionism against foreign cultures. And we need to bear in mind that there is a strong linkage between commercial freedom and political freedoms. You may not buy into the principle of modernization theory that one leads to another, but I'm 100% sure that if you start to enforce commercial restrictions, it will inevitably lead to political restrictions. I don't want any government to say what kind of culture is acceptable and not acceptable or in favor. The principle towards audiovisuals and how we want to encourage minorities and language and the cultural variety and access to culture needs to be modernized in the age of internet.
I think there are some really good reasons not to include an IP chapter. For one, levels of protection are already really high. That's mentioned earlier. For another, including an IP chapter is asking for trouble. ACTA is not easily forgotten in the internet community, and we can say 100 or 1,000,000 times that this is something completely different, but I'm not so sure that the internet community will hear that. Moreover, aiming for a limited number of issues, which sounds like a prudent approach advocated by the European Commission, may easily lead to a large number of issues, and you already see that, particularly on the American side, the number of IP issues is already expanding.
To remake the point again, if we don't like what's in TTIP, as the leaks come out, in the same way as transparency, or lack thereof, was probably the best tool to kill ACTA, the lack of transparency will serve the same purpose again. I seem to be encouraging you to do what's in your own best interest. I don't see the value of non-transparency from your perspective.